Good morning, ma'am. You're Louisa Magruder.
Yes, ma'am.
And Ms. Magruder's here with her attorney, Mr. Bynum. Ms. French is here on behalf of the state. Ms. Magruder is on probation and cause number 16-25158 for the second-degree felony offense of sexual assault of a child, was placed on that probation January 29th of 2018. We were previously in court and Ms. Magruder entered pleas of not true to counts 1 through 5 of a motion to revoke unadjudicated probation. Case was set for a hearing today for sentencing. I have received and reviewed the pre-sentence updated report. Have you both had an opportunity to review that report?
I have, Judge.
Yes, Your Honor.
Are there any corrections to that report?
None from the state, Your Honor.
Judge, I would like to make some objections to the report, but if I may, I'd like to also point something else out to the court. This morning, I filed a application for a writ of habeas corpus under Article 11.072 in this case, and I have a courtesy copy for the
I
court.
have a copy of it.
So
I don't think this is the appropriate time for that because Ms. Magruder is on a deferred probation and there is no conviction, if I'm correct, for this type of argument. I think if she were to be found guilty and her probation revoked, I've reviewed it. If I can rule on it if you want, or I can hold it and then, I mean, the gist of it is that you're saying that trial counsel was ineffective and that her plea was not knowing, voluntarily, and intelligent. Is that correct?
yes, Judge, and in addition that there's an as-applied constitutional challenge in ground one regarding the strict liability. If I may, if this case were to result in a conviction, then that the proper habeas vehicle would be Article 1107. But since it is still a community supervision case as of this morning, the proper vehicle is still 1107-2. And having filed it at this time, I believe that the court's issuing the writ, which the proposed order is on file, is mandatory, and that even if the case were to proceed to an adjudication and even a sentencing today, that the 072 matter would remain open and need to be heard.
Your Honor, may the state be heard?
Yes.
I've talked with our appellate chief, and she's not received any notice of this 11072 writ application. That would be appropriate for the appellate division to see and respond to before there is any testimony or argument regarding that application.
So I just received this morning. We're set for sentencing today. What I'm going to do is hold that writ. I'm not going to rule on it. I'm going to give the state time to prepare for any writ. I will have our counsel take a look at it as well. And if at that point I require any affidavits or testimony, we'll get it set for the appropriate hearing at that time.
Okay, thanks, Judge. The only other housekeeping matter is, and I have a paper copy if the court would like, the order issuing the writ of habeas corpus is a mandatory. It doesn't create any relief or anything. It's just that is the mandatory statutory provision to begin the process. And I would ask the court to.
I'm not going to sign that today. Again, I'm going to take a look at it when I have more time before I sign any order that I haven't had an opportunity to review the entire writ. Look at it with my counsel that works for the courts before I sign anything. So again, I'm going to hold that. I'm not going to start any process at this point. It was filed today, just a couple hours before the hearing. So I don't think it's something that I've been in court all morning. I haven't had a time to take a look at. Ms. French has not either. And so again, that's going to be just on hold. I'm not taking that up at this time.
Your Honor, may I be heard on one more matter?
Yes.
I was in court at 9 o'clock this morning for docket, and sometime maybe around 10:30, 10:20, I happened to look at my email on my cell phone to find that there's a motion to compel discovery and for in-camera review of the state's file And the only thing that I would like to address regarding this motion at this time is that it refers specifically to the 11.072 motion and appears to suggest that the state has not has not complied with discovery. And this is a motion to revoke probation. I did provide discovery to the defense counsel on the motion to revoke, as well as the administrative hearing, which I'm not generally required to do, but I do to be helpful. And also the pre-sentence investigation report. So I would also like time to respond to this motion to compel. As I said, I just briefly skimmed it, but those items stood out.
Well, based on the state's, I guess what I don't understand, Mr. Bynum, is why this is being filed today. We're here for a hearing. We're going forward with sentencing today. Ms. French has represented to the court that she has provided discovery with regard to the motion to revoke, which is what we're here for today. There's already been a plea on that underlying offense, and so we're going forward with the motion to revoke hearing on sentencing at this time. I'm not going to sign or grant any motion to compel. It sounds like they have already complied with everything they're required to do, plus some, to give you whatever information you need with regard to going forward with this hearing. So we're going to go forward.
Can I be heard about that, Judge?
Yes.
So the argument in the motion to compel is twofold, right? And I can tell the court, like, since it's an unadjudicated case, I believe that the standard discovery rules apply, and discovery is not limited to just the administrative documents and the matters regarding the motion to adjudicate guilt or the motion to revoke unadjudicated probation. That, you know, she is here being sentenced on the underlying offense, and I'm asking for discovery regarding the underlying offense, which I still haven't been provided. So my objection to proceeding today would be that on this ground would be that I have not received discovery after a request of the offense that we're here for sentencing, and that I think that the Morton Act requires that. The second fold argument here is that in 11072 habeas matter, which at this point is on file, that I have an additional ground that creates a discovery obligation in the state, since it is an 072 matter, contrasting that to 1107 matters, which have their own kind of scheme to replace.
Here's what we're not going to do. We're not going to go forward again on any 11072 matter today, or anything that was filed 2 hours before the hearing. And so we're going forward. You've been provided the updated pre-sentence report. It sounds like you were provided the original pre-sentence report, as well as administrative hearing and other information that Ms. French is relying on with regard to the hearing that we're here for today. The pre-sentence report that you received from before does have the police and court version. It has the defendant's version. It has a statement of interested parties. So you have already some of that information, in addition to, obviously, I'm sure, visiting with your client. So at this time, we're going to go forward. Ms. French, you may call your first witness.
Your Honor, may I respond to one thing to
Sure.
give court notice of? In 2016, Councilman Audwin Samuel, not Councilman, Counsel Audwin Samuel was the attorney for Ms.
It was
Magruder.
actually Mr. Sean Samuel.
Oh, Sean Samuel. I'm
That's
sorry.
fine.
I saw Samuel very quickly. Sean Samuel was the attorney for Ms. Magruder. And I did check to see that he received the media in this case and signed for it. And while I did not have time to also search for an email stating that he had received discovery in 2016, which doesn't show on our current system, the state would point out that she did have the benefit of counsel who did receive discovery under 3914 in the original case. Now, I do understand that Mr. Bynum is trying to make law on this 10-year-old plea of guilt and deferred adjudication order. I would feel more comfortable, Your Honor, if we address these things before we have a sentencing hearing, but I'll do what the court would like to do. I feel there are allegations that should be responded to by historical document. I'm also guessing that somewhere in the court's file of this matter, there is a discovery certificate showing discovery was given under 3914 in the original case. And that would be important to note. I'd like to be able to gather certified copies of those documents in a written response to these motions.
Just a minute. Because this plea was taken before we had our current system, I'll have to look and see. But we had those certifications like we do now. I mean, they certified during the plea. But all right, so here's what we're going to do. Ms. French, I don't disagree. I want to give you time to make sure, and obviously time for me to make sure that there's nothing that we do today that would get us reversed and us be right back here. So I'm going to reset the case. I'll give you guys a date. Ms. Holmes will send that date out. I'll take a look at everything and then we'll go forward in just a few weeks on that. All right, Ms. Magruder, you can go back with the bailiff. And I'm also, once you get that date, for the hearing, I'm going to order at this time that any motions that either of you feel necessary to file must be filed 7 days prior to that sentencing date or hearing date, whatever it is. There will be nothing that's taken up that is not filed 7 days prior to that court date. All right.
And Judge, could I just tell the court I'll make whatever accommodations I can, except the last 2 weeks of May. I have some inflexible travel.
If you'll just make sure that you have filed a vacation letter with Jefferson County. So when Ms. Holmes does the reset, that should pop up and she'll see it. Otherwise, there's nothing I can do. So make sure you get that filed today. All right, Ms. Magruder, you can go back with the bailiff.
Judge, on this case, with the court's permission, we're going to proceed on the lesser included. He has agreed to some stipulations that I would rather not put on the record. If the court can read between the lines on that.
Sure.
And also the co-defendant, for your information, was in custody in Orange County on a motion to revoke, I believe, a misdemeanor one. I've spoken with the prosecutor over there. It's my thought that probably Ms. Holmes let me know Louisiana has since picked him up, that they probably led him to credit the time on that MTRP, and Louisiana grabbed him before we could grab him back. And that may ultimately dispose of the entirety of this case.
All right, sir, you're Devin Murray. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Murray, in cause number 26 DCCR 0346, the state's elected to proceed on the lesser included offense of robbery from January 15th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. have no contact at all, communication with the co-defendant, and that's Lugo.
Jesus Lugo.
Jesus Lugo. You understand?
Well,
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Murray's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty to the lesser offense of robbery freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you in the case, and then we'll come back later for sentencing. So based on all of that, Ms. Malfino, what's the state's position with regard to a reduced bond?
The state is in agreement with that, Your Honor. He does not have any criminal history to speak of other than a possession of tobacco by. All the criminal history is really associated with his co-worker, Mr. Lugo.
All right, so. He's pleading.
No, I know, but. Okay.
So, what I'm going to do, Mr. Murray, based on the nature of your plea agreement, is reduce your bond in your case to $1,500. If you make that bond, it is important that you understand a condition of that bond is to have absolutely no contact or communication with Jesus Lugo. And to do everything you're supposed to, go straight to the probation department. If you get released, get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. If you get arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. So it's very important if you make that bond that you get out, you do exactly what you're supposed to, go straight to probation, and then we'll see you back here at sentencing. All right? You can go back with the bailiff.
Yeah.
Go through them and I continue, but either way, it's kind of the same.
Okay.
All right. Again, you are Jameldrin Wilridge, correct? Speak up for me. And will your client waive the formal reading of the indictment?
He does, Judge.
Find it now. Mr. Wilridge, in clause number 25, DCCR 1804, you're charged with the second-degree felony offense of burglary of a habitation from August 29th of 2024. And how do you plead to that charge?
He guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow this agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And the agreement shows that this is for a 10-year deferred probation. What about, this is the one with the shoot. What about restitution? Right, this is the one where he went.
Yes,
It's all the shoot.
It was 100,
It was a lot.
probably 100 pair of Jordans. You would think I would know how much those cost.
So here's what I
Yeah.
might do, just so that I have everything that I need, go ahead and get a pre-sentence report.
Okay.
You can get with them, get
Yes,
a
ma'am.
restitution amount. You are going to be required to pay restitution. So if you still have some of the shoes, find them, get them, talk with Mr. Lewis. They can be returned, so you don't have to pay for them.
Okay.
He did get it all back?
I'll
Okay.
confirm that. Your
So
Honor.
we're gonna just get that confirmed between now and then, and I do want to go ahead and kind of get an update so that the new case is in a PSI, since we don't have it, the new case. I don't need a, little update on the probations, for sure, double check on ISF and how that went, but it sounds like there's not an issue, but I just want to make sure. And so do you also understand, Mr. Wilridge, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection, Judge.
It's admitted. Is there any evidence Mr. Woolridge is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can just have everything in front of me that I need, make sure there's no other issues, and then we'll go forward with sentencing at that time. Any issue with me releasing Mr. Woolridge since he has been doing okay?
No, Judge, if only if wouldn't mind if I just hold on those MTRP dismissals until that sentence
Yeah,
date.
I
just
think
in
that's
case
what
something
makes sense.
pops up.
I think that makes sense. So, Mr. Woolridge, what I'm going to do in your case is reduce your bond to $1,000, but I'm going to make that a personal bond. What that means is that you don't have to pay the money. You will be released today. So what I need to do though is, on those motions,
Unless it would make it easier for you if I just dismiss
just
it.
do personal, I can just set personal bonds on all of them. So I'm gonna set personal, so on all three cause numbers that you're on probation for, which is 18-28743, 18-28744, and 18-30139. I'm going to set bonds on all of those where the motion to revoke are pending at $1,000 also, and make those personal bonds. So what all of this means is that you're going to get out today without paying any money. Some very, very important things though, between now and when you come back for sentencing. Obviously, you're on probation still for the other three. You need to report to probation for two things. One, because you're still on probation. Two, so that they can do that updated pre-sentence report about the new case and kind of how things are going right now. Okay. If you don't go straight to probation when you're released to do all of that, then you run the risk of me not accepting this plea agreement. Things could obviously be much worse. Do you understand? Speak up, please.
Yes, ma'am.
Also, if you're arrested for anything between now and when you come back, you run the risk of me not accepting this plea agreement, and then you've got those motions pending and things could obviously be a whole lot worse. You understand that as well? And so, was there a co-defendant in the burglary? Or no? Okay.
I don't think so.
You do, I am going to order as a condition of your bond also, and it will be a condition of your probation that you have absolutely no contact or communication with Jasmine Adams as the owner of that apartment. And that apartment was where? Do we have an address?
That apartment was located
I can probably get that.
at 4165 Old Dallin Road. It was apartment 91, but I would suggest.
So,
you stay
yeah,
away from the
so-
entire complex.
Correct. That's what I'm gonna do. So you cannot go anywhere near 4165 Old Dallin Road. Any of it, none of the apartments. Do you understand?
Yes.
Anything else that you feel like I need to order as a condition of the bonds?
I'm just double checking for any type of co-defendant. No, Your Honor, I don't believe so.
Okay. All right, then we'll see you back at sentencing. Again, make sure as soon as you're let out of custody that you go straight to probation. All right, sir, you're Jabbar Bell again, right?
Yes, ma'am.
And so we're back on cause number 26, DCCR 0274. And in that case, Mr. Bell, I'm going to start from the beginning. In that one, you're charged with the state jail felony offense of evading arrest or detention with previous convictions from January 21st of 2026. And the indictment alleges you were previously convicted of evading arrest or detention March 13th of 2017, and then again November 8th of 2021. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
Now, Mr. Parker, the state has filed a motion asking to amend the indictment to include those two prior offenses that we've already gone through and read in the other tech cases. Do you have any objections? And you will waive your any time to review that,
Yeah,
correct?
Judge.
So, Mr. Bell, the indictment, I'm going to grant the motion to amend the indictment further shows now that you were arrested previous or convicted previously of unauthorized use of a vehicle, a state jail felony, June 24th of 2019. And after that was final, you were convicted of burglary of a building, a state jail felony, June 26th of 2023. And are those prior convictions true?
Yes, ma'am.
And in all three of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
Objection?
It's admitted in each case. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find in all of your cases that you entered your pleas of guilty and true, freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. And cause number 26, DCCR 0139, find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. Find all of those prior convictions that you pled true to, true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, excuse me, clause number 26, DCCR 0140, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find all of the prior convictions that you pled true to, true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 26 DCCR 0274, again, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Find all of the previous convictions that you pled true to, true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All three of these cases will run concurrently, which means together at the same time. And I'm going to hand you in all three cases the trial court certifications that shows that these were agreements that I followed, and so you waived any right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. Thank you, Ms. French, for getting that taken care of, and Mr. Parker.
The courtroom was expected to move straight into sentencing, but everything changed when the defense filed a last-minute habeas corpus application just hours before the hearing. As attorneys argued over newly raised legal issues, Judge West made it clear that the court would not rush through motions that neither the prosecution nor the court had sufficient time to review. Repeated attempts to revisit the new filings were firmly stopped, with the judge emphasizing that the hearing would remain focused on the scheduled proceedings, not issues introduced at the last minute. Concerned that moving forward without proper review could create problems on appeal, Judge West made the unexpected decision to reset the case instead of proceeding with sentencing. The court also ordered that all future motions must be filed at least 7 days before the next hearing. It was a reminder that in court, timing matters just as much as the law, and preparation can determine the course of an entire case.